Right now on the Daily Debrief.
He was just kind of giving some kind of strokes or something like that.
A fifth accuser takes the stand to accuse a former NFL player of sex crimes. Also,
it's just bad DNA, I guess.
The father of a man accused of murdering his 5 children blames genetics. And after nearly 6 months, the jury finally has the case of a California man accused of murdering a family of 4. Does the defense have a chance?
The DA in this case has hidden the truth from you.
Real-life criminal trials are on the Daily Debrief. It's Thursday, May 30th.
Welcome to the Debrief, everybody. Aaron Keller, along with Mike Korobanix, Brian Buckmeyer, and, of course, Francie Hakes will be joining us in a moment. All 5 women who are accusing a former NFL player of sex crimes have taken the stand. Defendant Kellen Winslow II played 10 seasons with the Cleveland Browns and other teams. He faces 12 charges, some in multiple counts. The maximum penalty, if convicted as charged, is life with the chance for parole. The accusers are known only as Jane Does. Jane Doe number 4 was 17 years old when she says she was attacked by this defendant and his friend named Matt.
I opened my eyes, and my face was being pushed into Matt's groin area.
Where were you when you woke up to that, or when you came to?
Is it a bedroom? On a bed.
Do you remember if that was upstairs or downstairs?
I don't know. I don't remember.
Do you know how you got from the couch to the bedroom being on a bed?
No.
What was Kellen doing at the time that he was pressing your head towards Matt's groin area?
He was penetrating me from behind.
Was he having sex with you?
Yes.
Was he having sex with you at the time that you regained consciousness?
Yes.
On cross-examination, the defense pointed to a prior sexual encounter between Doe number 4 and the defendant. Of course, it appeared to be consensual, according to the testimony. The defense also asked about drinking.
It was because his father was an NFL football player, or famous football player, that's the reason you didn't think anyone believed.
It was more, I was a 17-year-old drinking underage, and the fact that I had messed around with him 2 weeks prior. Why would anybody believe me?
Okay. Did you think that you might have, that you did anything to cause any of this?
No.
Okay. But you wouldn't know, if you blacked out, you wouldn't know anything that happened during the blackout, right?
Correct.
You would agree with me that when you say escalated, it means that you were essentially part of it from the start?
I don't know.
Okay.
The fact that I said stop.
Right, I understand. But once again, your words were escalated, and I'm just wondering why you would use that.
Because it escalated to a point where somebody's penetrating me with their penis.
Okay. So
when somebody tells you to stop, you stop, okay? Regardless of whatever I may have
said.
I don't know what I said.
Or done. I mean, I'm just saying, look, you don't remember very much of a particular segment of the evening. That's true, isn't it?
Yes.
And that we don't know how long that segment is, whether it's 2 minutes or 2 hours. We don't know, do we?
No.
Right? So the point is that you have said things my question to you is, you have said things in your testimony and in your interviews with law enforcement where you think that you may have done something or said something which contributed. Is that fair for me to say?
That's fair for you to say.
Okay. The husband of Jane Doe number 4 described discussing the alleged attack with the accuser at various points in the relationship.
I remember she was upset that day, kind of crying and kind of like distant from me. I remember she was talking about back when she was in high school, how she was raped.
Do you remember her using that word?
Yes.
Did she tell you that she ended up in a room inside a house?
Yes.
What did she tell you she remembered after ending up inside a room?
She said she was in the room and there was a couple different guys around, and that she was telling them to stop and she didn't want what was happening. She said that somebody was behind her and she was telling them to stop and they wouldn't.
What was the name that she told you of the person that was behind her?
Kellen.
Did she tell you what Kellen was doing when he was behind her?
I didn't ask specifics about it.
Was she describing that she had been raped by this person?
Yes.
And now to testimony from accuser number 5. She described 2 incidents with the defendant. The first occurred near some exercise equipment.
What was he doing with his penis while you were facing each other?
He was just touching and giving strokes to his penis.
Are you saying that he was giving strokes to his penis?
Yeah, just touching. And he kept his legs open on the machine, so I can see what he's doing. I wanted to say something, but I couldn't, so I was just probably frozen of fear. And he said to me, with a very funny and happy face, "Do you see this?" Pointed his penis. He said, "Do you see this? Do you like it?"
Were you uncomfortable by the fact that he had been touching himself in that way?
I was so upset. I was feeling so bad, but I didn't want to leave. I wanted to be there. I didn't want for him to make me scared. I wanted to continue doing my routine.
The second incident accuser number 5 described happened in a jacuzzi.
How close was he to you?
About this close.
Indicating about 18 inches.
I could do anything. I guess when you're so afraid, you just kind of frozen.
Could you see what he was doing?
I could not see, but I can think what he was doing. He was masturbating.
Objection. It's non-responsive and speculative.
It is not, Your Honor. She's describing.
No, I don't entertain speaking objections. The answer will stand as to her perception. You can inquire on cross. The answer will stand. Go ahead.
Thank you, Your Honor. Why was it that you believed he was masturbating next to you?
The movement of his hand, he was just doing the kind of when you masturbating do. With his right hand, he touched my left arm.
Was that before, during, or after he had been doing the motion that you described as masturbating?
That was after.
Could you see his penis when he grabbed your arm?
No, you could not see nothing in that kind of water.
Joining me right now on the debrief are attorneys Brian Buckmeyer, Mike Korabanix, and Francie Hake. So Francie, let me start with you. You're a former federal prosecutor. You handled sex crimes cases like this. This issue of consent with doe number 4 is rather interesting to me because my understanding is that she was 17 at the time when this first encounter, which everybody is calling consensual, happened, but the age of consent is 18. So why are we not seeing an additional charge here because of that?
I don't know. I don't know why prosecutors wouldn't have brought a charge of at least statutory rape. You're talking about children here. They do not have the capacity under law to consent to sexual activity. So it was a crime for him to engage in any kind of sexual activity with her, whatever her desire. Yeah, I mean, and it's forming an interesting case here. So, Brian, let me ask you this one. The cross-examination of number 4, doe number 4, was indeed cross. It was combative in various ways. She had her arms folded and she was kind of fighting back with the defense. Does that actually score points for the prosecution?
I believe it does. Unfortunately, a lot of these cases cut both ways. I think what is going to be presented is you see this combativeness with the alleged victim, and it's understandable why you'd be combative. You're putting the alleged victim on the stand and cross-examining her. Well, she, in her mind at least, believes she's the victim. So why are you questioning her in this manner? She's going to be defensive, she's going to be combative, and that's going to be either for the prosecution to explain away or for the defense attorney to do the same. Mike Korabanix here. Doe number 5 says that she couldn't see what was going on under the water of that jacuzzi, but she knew he had to have been masturbating. Well, if she couldn't see it, how does she know?
Well, her testimony is, I think, pretty powerful in the fact that she, while she may not have seen it, even the camera angle where she showed the motion of the arm, things of that nature, I don't know if that was a really great objection by the defense because it sort of just highlighted it and allowed her to explain it further. So I don't know if that was really a great move.
This is an interesting moment, Mike, where I threw you a pure defense question and you actually took the prosecutor's side with it. That's interesting.
We all
don't
have
see
our
that
off
every
days.
day. Well, we'll talk to you all in just a couple of minutes here. An attorney made famous in the Netflix film Making a Murderer is on the other side of the law yet again. Len Kaczynski scheduled to appear in court this very afternoon to answer charges he violated a restraining order. This all stems from Kaczynski's acquittal last December of an accusation that he stalked his own court clerk. He won his case, but the restraining order against him remained in place. And that case goes. Still ahead on the debrief, a defense expert backfires in the case of a South Carolina man accused of murdering his 5 children one by one. Plus, the state goes for a motion. The defense accuses the state of lying yet again in the death penalty case against a California man accused of murdering a father, a mother, and 2 children. We're back to that case after the break here on the debrief. A man accused of murdering his 5 kids is pressing an insanity defense in a South Carolina courtroom. Timothy Jones Jr. could be executed if jurors find him guilty and then agree on a punishment. He admits taking the lives of his children, ages 1 through 8, and then driving around with their bodies in the back of his Cadillac SUV for more than a week. The defense still has the case and called the defendant's father with this testimony about mental illness in the family tree.
This is the Tim that I was scared I was going to see one day. I mean, he's got some relatives and his mother. You know, I mean, unfortunately, they're not right. You know, and I seen his mother go through it. I seen her brothers, Eddie, Chris, Arthur, and Domingo killed his damn self. I mean, it's unfortunate. It's just bad DNA, I guess. He's sick, man.
If you'd ever thought that the babies were in danger.
Come on. I mean, there ain't no way I would let anybody ever touch them babies, you know. And I, you know, I could have talked to him that day, and I didn't because my son would never do such a thing. But the woman I knew in Cindy and you know, and yes, I mean, I don't know how to explain it, but I guess you'd sort of have to live it, know it, didn't say it, you know. I mean, that's all I can tell you, folks.
And then, whoopsie, this happened. The defense called a court-appointed doctor to testify that Jones did know right from wrong. Listen to this and ask, how is this helping the insanity defense?
It's my opinion that on the dates of August 28th to 29th of 2014, Mr. Jones would have been able to distinguish legal and moral right from legal and moral wrong, and could recognize his actions as legally and morally wrong. He used incredible amounts of spice. He says up to 5 times a day.
And you ultimately gave Tim a diagnosis.
I did. I diagnosed Mr. Jones with a substance-induced psychotic disorder from spice, or synthetic cannabinoids, as we call it. And what I mean by that specifically is not a delusion, because it wasn't a fixed false belief, but just to have the paranoid thought that my 6-year-old child is somehow going to use an electrical outlet to kill me in my sleep. That's not a normal thought that I think most people in their right mind would think.
Right, it's psychotic.
Yes, well, I think it's paranoid, yes.
And this is a substance-induced psychosis, right? That he was in at the time of the offenses on the 28th.
Yes.
And that, but for the spice, we wouldn't be here.
I don't think so, but you know, I'm not a fortune teller.
Maybe a nugget in there to help the defense, maybe not. We continue to monitor that case. And now to California, where the state and the defense are fighting it out right until the end in the capital murder case against Chase Merritt. He is accused of killing business associate Joseph McStay and the entire McStay family in 2010. All 4 of the McStays were beaten with a hammer. Their bodies did not turn up until years after they disappeared. During closing arguments, the prosecution pointed to a cleanup at the home of the victims and the defendant's lack of an alibi.
How did that paint get there? Other than after Summer being disabled, rendered unable to defend herself, someone used paint in that house. Why would someone, after disabling the mother of 2 children in that house, need to use paint other than to cover their tracks? The fact that there is no blood stains or blood pools could only be due to the killer's actions in either how he carried out the murder or how he cleaned up the murder. Here you have significant blocks of time where the defendant has no alibi, has no cell phone activity to put him anywhere, plenty of time. You have a defendant who does not report Joe missing, does not ring the bell until February 9th.
The prosecution said the motive was money for these killings and pointed to the defendant's DNA on the gear shift, steering wheel, and radio of the victim's vehicle, but not on the door handles or anywhere else. The defendant says the DNA got there because he had lunch with victim Joseph McStay the day McStay disappeared and shook hands with him at the conclusion of the meal. The defense came out fighting on all these issues and accused the prosecutor of flat out lying to the jury multiple times. And what about some missing cell phone data in this case? The state says Chase Merritt shut his phone off during part of the alleged crime to evade detection. The defense countered with this.
The DA in this case has hidden the truth from you. And they set out on a course to hide the truth from you. You heard from Brian LaRocque. He testified about PayPal records, and you also heard from a representative from PayPal, Sarah Kane. Not Joseph's PayPal records, although you heard about those too. I'm talking about Dan Kavanaugh's PayPal records. Do you realize, ladies and gentlemen, that the prosecution never even requested those PayPal records? Do you realize that law enforcement, Sergeant Smith sitting here and his team, never even requested his PayPal records? So they didn't know that Dan Kavanaugh had diverted payments from the production business online to his own account. They had no idea because they never requested it. Even more shocking, they never requested Dan Kavanaugh's bank records. Dan Kavanaugh, on February 10th, either the day after or the day of, he makes the call for a welfare check on his friend, Joseph McStay. He's dipping into his PayPal account and stealing Joseph's money. Did Mr. Kavanaugh think that he wasn't coming back? I mean, Mr. Kavanaugh had to have known when he was dipping into that account and swiping $13,000 right off the bat that there's going to be a problem when Joseph gets back, unless you know he's not coming back.
Outside the presence of the jury, one of the prosecutors basically flipped out about a comment the defense made about Dan Kavanaugh, that alternate suspect the defense argues is the real killer.
This court made some very specific rulings about not allowing either side to comment on the absence of Dan Kavanaugh being called as a witness. This court allowed defense to call Gary Robertson to testify that they could not find him, and the basis for that was because their investigator had looked for a few months, and the court said that they would allow that, but that neither side would be able to comment on the absence of Dan Kavanaugh being called as a witness. And that's exactly what defense just did.
Well, I think the potential failure to call potentially logical witnesses is a fair comment on the evidence, and certainly the people can respond that the defense had an equal opportunity to locate and call Mr. Kavanaugh.
This court ruled that neither side could comment on that. And that was the basis for allowing Mr. Robertson to testify. I would like the court to uphold its previous ruling and admonish the jury that they're not to consider that.
That was what the court indicated, that because we said they're going to do it anyways, and the court said, well, if they do it, then I'll admonish them in front of the jury.
Because this is exactly what we knew would happen.
Maybe you can find that in the transcript.
Absolutely.
And I'll be happy to look at that.
The jury in this case is considering the following possible verdicts: guilty of first-degree murder, guilty of second-degree murder, or, of course, not guilty. So let's turn to the panel one more time. Francie, what do you make of this so-called temper tantrum here from the state about the defense's ability to keep pressing third-party culpability? My understanding is that generally they can press that theory unless there's a pure relevance issue.
Well, that's true, Aaron. I'm not sure I would characterize what she did as a temper tantrum. If she's right, if the court made a ruling based on sort of a quid pro quo, I'll let the defense call this witness, but no one can comment on the fact that we don't have Kavanaugh, and then the defense commented on the fact that we don't have Kavanaugh, then that violated the court's ruling, and that is unfair to the state.
Okay, well, but if the court made a bad ruling, then the judge sort of walks it back in the middle of trial, realizing I made a bad ruling, then the state can't get very upset about that. The state should know the law just as well as the judge and the defense.
Well, the state obviously knows the law, but the state is relying upon what the judge said he would not allow them to do. And now you can't unring the bell. The defense has commented to the jury on the lack of Kavanaugh's being present. And maybe the state's trial strategy would have been different. Maybe they would have called other witnesses to talk about how they too could not find Kavanaugh before the jury. But now there's nothing the state can do to show the jury that the defense didn't meet its burden. And in fact, you've shifted the burden really here, because the judge has said that the state doesn't have to explain why they don't have Kavanaugh, but now they really do have to explain it.
This issue is complex. Look, Mike, I'm going to ask you this one real quickly here. On rebuttal, the state seems to have changed its theory of the case. First, they said the family was killed at home. Now they're saying, oh, it's a question mark. We don't know. Credibility issue or what?
I think it's horrible for the state that you put this case together. It's almost like a Tolstoy novel. It's been going on, and now you change in midstream. Well, actually in the middle of the ocean, you change. I think it's horrible.
As you're coming into harbor, you change. Okay, then you decide you want to go to another harbor. Brian, quickly for you as well. A juror says he or she can only deliberate for 3 hours a day. The judge is going to let this case go into deliberations in half days from here on out. What's going on with that?
That's going to be very complex in terms of how they decide this case. It's going to have stopping and starting because they're not allowed to deliberate when they're not all present. So we're going to see this drag out for a long period of time, half a day here, half a day there.
Oh, gosh. I mean, this case has been going on almost 6 months. Great discussion from the panel here on the debrief. Let's do it again sometime. The four of us will duke it out yet again. We appreciate those of you for watching us. Our live trial coverage will continue for those of you watching on the Law and Crime Network in just a moment. I'll be back later tonight with testimony in the Winslow case.